Can an Australian patent be invalidated as a result of secret use? The Patents Act provides an invention is patentable, provided that the invention was not secretly used prior to the priority date. The rationale behind this provision is to prevent the extension of the statutory period and the de facto monopoly of the patent prior to the priority date, without fulfilling the obligation of public disclosure. A number of exceptions to this rule apply. These activities are contained within Section 9 of the Patents Act. Firstly, reasonable trial or experiment only. Secondly, any use occurring solely in the course of a confidential disclosure. Thirdly, any other use of the invention other than for trade or commerce. And finally, any use by Commonwealth, a state or a territory where the invention has been disclosed to them. Therefore, this issue principally arises where a patentee has commenced trade or commerce. The term use is not defined in the legislation, therefore it has been left up to the courts to determine. The case of Azuko provides some guidance in this area, though decisions will still be made on a case-by-case basis. The court stated that the focus should not be on the use of the term secret or use, but rather a practical test should be applied. The example in Azuko was the manufacture of drill hammers for use in mining, before a patent application had been filed. It was the investor's intention to sell that hammers, and a willing purchaser had been lined up, but the legal steps for making a formal sale occurred after the patent application had been filed. The judges in this area adopted very different approaches to determining use, and this continues to provide confusion in this area. The court held in Azuko that the investor's actions did not amount to secret use, and the simple manufacture of goods does not fall within this category, though the formal sale of goods would. The issue is therefore the steps between these processes and where the line will be drawn. Patent applicants will often try to rely on the exception of reasonable trial or experiment of goods only. The scope of this defence is considered in Bradkin Resources versus Link Engineering. In this case, Link's manufacturer entered into a contract with BHP for trial and evaluation of 3 prototype wagons. These wagons were handed over before the priority date. It was decided that if BHP were satisfied with the trial, they would then pay Lynx for the goods. BHP were satisfied with the trial and then purchased an additional 109 wagons. Here, Bradkin argued that the supply of the wagons was purely commercial in nature. The court held that this did not amount to secret use, although the court did state that the circumstances in this case were close to the boundaries of the exception to the rule. Despite this, the intention for ongoing testing and improvement ultimately led the court to determine that this was within the exception. The court stated that the use of the term only should be construed loosely, and some element of in trade or commerce could apply, or otherwise this defence would rarely be applicable. This case also provides a useful summary, confirming that manufacturing only will not amount to secret use, nor will capital raising or profit sharing agreements. Further, advertising does not amount to an offer for sale or use, though the distribution of a prototype or samples to customers would classify as use within the definition. There still exists some uncertainty around the definition of use in this area, though these 2 cases provide significant guidance. The scope of this issue will likely be limited by the recent amendments in this area. Section 9 of the Intellectual Property Laws Amendment Raising the Bar Act alters and provides a grace period for secret use. Section 9 provides that any use of the invention within Australia within 12 months of the filing of a complete application claiming the invention will not be taken to be a secret use. Similar pitfalls apply to this grace period, and patent applicants should be wary of the potential negative consequences. Despite the legislative amendments, patent applicants should be wary of commencing commercial activity before a complete application is filed.